What's up, family? I don't even know if this gonna work either, but I'm gonna try it. I swear. Dennis, where the hell you at? Let me see something.
Quite a few documentations that we have attached filings, and we have more that we intend to present at the hearing in this case to show that she did receive as a witness in this case. How can Mr. Wade not have relevant into this inquiry? That is the real question here. He probably has the most relevant information to this inquiry. Same as Ms. Willis. She probably has the most relevant information to this inquiry. Mr. Bradley, the state has taken it upon themselves to file a motion to quash Mr. Bradley's subpoena. Mr. Bradley had a motion to quash. The divorce in this case was not filed until November 2021. The only privilege that can be asserted is things that were said in furtherance of legals. So if Mr. Wade made statements or comments to Mr. Bradley in furtherance of legal advice, we're not going into any of that. We don't have any intention of getting into a privilege dispute, what was privileged and what was not. The relevant information that Mr. Bradley has to this inquiry is that this relationship started prior to Mr. Wade being appointed as a special prosecutor in this case. He has firsthand knowledge that this relationship predated that. He has knowledge, and not privileged knowledge. The divorce section hadn't even filed at that point. He has personal knowledge, not cohabitated, had stayed at the same place. And I certainly don't intend on getting into an argument over what the term cohabitated means. They had stayed together. Mr. Wade had stayed at places that Fulton County was paying for Ms. Willis to stay at. He's got information about that. We have outlined all that. We've made a profit. That is not privileged information, Judge.
And unlike some of the, other witnesses that are here challenging their subpoenas, my inference from the supplemental replies that this is something that you have corresponded or communicated with Mr. Bradley about directly.
Yes. Only non-privileged information. Yes, Judge.
All right. And so let's put the district attorney and Mr. Wade in a separate category. I think you would still, now that the motion has been filed, need to make some kind of showing for the other.
All right, hold on. Let me explain what's going on. Okay, so this is a hearing on the Fani Willis fiasco, right? So there was a hearing scheduled on Thursday, February 15th. And in preparation for that hearing, what the lawyers for Trump, and that's Ashley Merchant that you see in the pink. She's one of Trump's lawyers. She's representing Roman, the co-defendant for Trump, who she basically started all of this. And she sent out a flurry of subpoenas to establish that there has been some impropriety, right? So her allegation is that there was a relationship between Fani Willis and Nathan Wade before he was appointed special prosecutor, and that's improper. And as a result of that appointment, she received a financial and personal benefit. All right. So we understand what the issues are. The judge took some time to frame the issue so that we didn't go astray. And what he said, and what all the papers are reporting is, he said, this is the issue, whether or not misconduct happened, because that could disqualify her. Yeah, he said that. He said that. Let me go back so I can play that part for you guys. Let me go back. Will they let me do it from here? No. Some fragging bullshit. All right, hold on. Let me go back because I want to hear that part. The judge this in the beginning, and it's worth hearing.
Just from the hearsay evidence, we've got conflict, Judge. There's also some other things, the Wade affidavit that we conflicts in. We've got the date. We've got whether or not they cohabitated.
I think
Whether or not they were in phones. that he was paid, that he used for travel with Mr.
Right.
If he had had any relations with, if he had had any relation
He might not
that
put
we
it on this
have attached to filings, and so if Mr. Wade made statements or comments to Mr. Bradley in furtherance of legal advice, we're not
Communicate with Mr. Bradley.
yes, only on witnesses if they would be fallback witnesses, for example. If Ms. Willis is not, if you don't force Ms. Willis to take the stand, then we would have to present witnesses to establish what Ms. Willis could be questioned about. And so some of those witnesses would be cumulative of what Ms. Willis testified, but they could be impeachment. It just depends. And so I'll go through all of those witnesses, Judge, as far as our belief that they have personal information. How I sort of categorized them was we had Willis, Sonia Allen, and Dexter Bond, and then Daisha Young. So Sonia Allen is the head of the anti-corruption unit.
Stop, pause, hold on. Let me come back. Okay, let me try to catch y'all up. So some of this is not relevant for our purposes, right? So the judge obviously is not going to allow her to inquire of anyone about privileged communication. Privileged communication is the communication you may have had with your attorney. Obviously, that is off limits. That's off limits. Now, this person, Bradley, that she's talking about is Nathan Wade's former partner or partner. And at some point, he did represent Nathan Wade. So there is a question as to whether or not the communications that he's had with Nathan Wade are privileged. And Ashley Merchant's position is none of this information is privileged information, and it's ripe for inquiry, right? And so Bradley is the person who was supposed to come testify, and apparently he's the one who has what's called personal knowledge under 611, personal knowledge that they had a relationship, it was romantic, and that it started before he was appointed. Now, Nathan Wade, in some of the court papers since this has been happening, has provided an affidavit in support of Fonnie Willis's motion to quash and have the court deny this motion. And in his motion, he admits that they have a personal relationship, and he says it started sometime around 2022. The problem with that is that he has prior affidavits where in his divorce proceedings and in other filings in his divorce case, he swore that he had no other personal, intimate relationships with anyone other than his wife during the life of their marriage. Now, these affidavits, and I'll tell you, all attorneys understand, affidavits are sworn under the penalty of perjury. Sworn under the penalty of perjury, which is why you hear them saying things like, he might take the fifth. He might take the fifth. Can you imagine the guy who was appointed to be the special prosecutor might take the fifth? He's ducking service. He will not accept service. What does that mean? Don't talk the lawyer shit. Okay. Service is when someone tries to give you those papers and say you're served. That's service. That is a order from the court for you to appear. Right? So he doesn't want to take the subpoena. So he's ducking service. So you'll hear some of that. Like, what are you doing, bro? That's crazy. That's crazy. There was reports that Fonnie was ducking a subpoena from Congress, that she refused to accept a subpoena by email, and that U.S. Marshals had to go serve her in person. Really? That's what you're doing? Okay. So the judge basically is saying, all right, you've got all of these people subpoenaed. You have to give me an offer of proof. That's what's happening right now. You got to tell me, how is their testimony relevant, and how is it not precluded as hearsay, and how is it not, some other rule of evidence that doesn't allow it? How is it not character? Some other reason, right? So the judge is asking her to tell, what does this person have to say, and how is it relevant, and when would their testimony come out? So she's laying out for them. Now we're going to see later on in the Zoom that there are it's a bunch of people on the Zoom waiting so that they can argue in response to what Ms. Merchant is saying. So All of the people that she subpoenaed is about 9 people. They have attorneys. They all went and got attorneys because nobody wants to testify. Nobody wants to talk about this shit. Yo. Oh, this is crazy. All right, let's get back to it. Play. Damn it. Damn it. Don't be laughing at me.
She's the one that started.
I can't see the chat, y'all. I don't know why it's not coming through.
Which is where most of the outside counsel work in the DA's office is coming.
Yeah, no chat coming through.
She has personal knowledge about those parties, about the financial benefit, about the contracts. She's the one that is head of the anti-corruption unit. And, you know, just to focus in on whether or not we have to talk to a witness before we subpoena that witness, there's no law that says you have to talk to a witness before you subpoena them. And that makes sense. Police officers regularly do investigations, and they talk to tons of witnesses. You talk to one witness, and it leads you to another witness. And you subpoena people who are not particularly willing to talk to you. I asked all these people to talk to me. It's not surprised that they don't want to. They also all have NDAs.
NDAs.
They've been asked to sign the district.
They got non-disclosure agreements.
They're hesitant, and I'm not saying these in particular, but members of the district attorney staff are hesitant to talk because
of course they are.
But court order such as a subpoena would alleviate any of those concerns.
So recognizing that, even if you don't have to talk to them, I think you still have to have some kind of good faith belief of what it is they could possibly say that is relevant, or that you could later impeach them on that then becomes substantive evidence, right? So what is it? Let's just start with Ms. Allen. She starts the anti-corruption unit. She may have been there at the formation of these contracts. Is there anything as part of that you think plays into these issues?
Just personal knowledge as to when the relationship started. These witnesses would all have personal knowledge as to when the relationship started.
And when we say, Jake, are we referring to just the fact that they knew each other, or that they knew that it changed or evolved?
That it was that the relationship predated Mr. Wade being high knowledge. And I've talked about witnesses, you know, when you're investigating a case, some witness may not have personal knowledge, but they might know someone who does have personal knowledge, things like that.
How do you know Ms. Allen has personal knowledge?
I like this
from Ms.
judge.
Bradley.
Okay. All right. And so, theoretically, if Ms. Allen testified and deny that, Mr. Bradley would be able to impeach her?
Yes.
Okay. All right.
And same with the other witness.
So that's basically her entire, most of her argument is that she wants to call these people because they have personal knowledge. Now, the other people that she wants to call are members of the security detail for Fani, because they have escorted her different places where she's been with Nathan Wade, according to Merchant, where they've cohabitated. Now, she's using cohabitate to overnight guests, overnight lodging, vacation. You slept overnight together, not that you live together. However, there is one other allegation that she wants to call a person who she believes has personal knowledge that they did, in fact, live together at one point. Yeah, that they did. All right. So I'm going to just fast forward just a little bit because I want you to see Fani's lawyer combating some of this.
If either of those came and denied having any knowledge whatsoever, you have someone who would impeach them having made a prior statement explicitly on that point?
Yes, I do.
So Mr. Bradley's going to come in. Okay, so this is
displays a misunderstanding of the
this
role of
is
these individuals, and
Anna Cross.
in particular the role of Ms.
Let me
Yuri.
back up a little bit.
Ms. Yuri was never part of the executive staff.
So she's
or-
representing Fani individually, I believe, as an individual, as opposed to as a prosecutor. And there are 2 other prosecutors there that are representing the state.
allegations here.
So this is her responding to what Merchant said.
Because even Ms. Merchant's recitation to the court of the facts and circumstances of why these witnesses are relevant displays a misunderstanding of the role of these
She
individuals.
just called her
and
dumb.
in particular, the role of Ms.
Y'all caught that?
Ms. Yurdi was never part of the executive staff or team. Ms. Yurdi was not someone who kept the district attorney's schedule or calendar.
That's not me doing that with this screen.
The allegations here are she worked on the media team was her role. The media team, not the executive staff or team or responsible for calendaring the district attorney's office.
But just to be clear, I mean, your motion doesn't cover security. That's
It doesn't. It doesn't.
So shut up.
The argument towards Ms.
So
Green.
stick to your.
Correct.
Can you do that? Thank you.
Correct.
I love this.
And the other
judge.
individuals, Ms. Merchant did make a representation to the court about how Mr. Bradley would know about the knowledge of Ms. Allen, Mr. Bond, and Ms. Young. That is, I think, relevant.
He has personal knowledge. She said it already.
The impeachment evidence she has would not be admissible.
Mm.
Likewise, the security.
Why would it be admissible?
I love this judge.
If Mr. Bradley heard that second or third hand that Ms. Allen knew this, or Ms. Young aware of that, or Mr. Bond said
Sure.
this to someone else,
That was the impression.
Right.
The impression I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms.
Right.
Merchant, is that accurate?
Directly overheard.
God damn it.
Or you from a
Well, essentially, that kind of all of them said Allen, Bond, Young, and then the investigators Hill, Green, and Ricks could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
All right, Ms. Cross.
Every last one of them. So ooh.
will be shocked
Yeah, I bet you would.
if Ms. Merchant is able to swear that statement.
Mm.
Shocked. I don't believe that's true. I believe even if it was true, and it's not, and can I just say, when we're talking about the timeline and what might be relevant in an evidentiary hearing, there is, I guess you could spend a lot of time.
She's tongue-tied. She don't have nothing to say.
Timelines and who is
You ain't got no point.
Should there be an evidentiary hearing? I understand
There will be.
it's ruling. There's an evidentiary hearing. What the state will establish with unequivocally
Really?
is that there was no cohabitation. District Attorney Willis and Nathan Wade never lived together, that the representations that have been made to date are just demonstratively untrue. For example,
You
allegations.
could just say they
that
untrue.
lived
You don't gotta say
together,
they're not demonstrably
in
untrue.
District Attorney Willis's home prior to District Attorney Willis's father living with her. And when the father moved in, then Mr. Wade moved out. Of course, that is untrue, and the state would be able to establish that Mr. Floyd, District Attorney's father, moved in, even changed his Georgia driver's license prior to the time that the District Attorney and
Changing his
Mr.
driver's
Wade ever
license
met.
has nothing to do
That-
with Wade living there.
Testimony from Mr.
So what?
Floyd would be that he lived there continuously and never saw Mr. Wade there. The
Oh, he gonna come live for
evidence
his
would
daughter?
be that the timeline
Ah.
that's being represented is either mistaken, if that's terribly,
Mm.
or simply fabricated.
Mm.
So I want the
Fabrication.
court to understand that this is a hearing that we're contemplating, and I understand the rulings. But to return to your question about Ms. Allen, Mr. Bond, and Ms. Young, I believe that the spectacle of calling opposing counsel to, in this case, did knowledge about a relationship, because they didn't have any knowledge about a relationship, and certainly none that contradicts the Wade affidavit. Calling them in to say that, and then another individual to say, no, I heard otherwise,
Is what the law
gives it
allows.
very little evidentiary value. I would put it that way. Even if the good faith basis that Ms. Merchant represents has very little evidentiary value.
I think the
Insofar
judge
as the
disagrees.
security staff was referenced and mentioned. Again, I don't believe there's a good faith basis for any witness to say that the two cohabitated. They never did so.
You said that
I don't
already.
believe there's a good faith basis for any witness to say that there was a relationship prior to 2022, as was represented in the affidavit. These witnesses, who have a host of other security sensitive information about the district attorney and her travels and her arrangements and the means by which she is kept safe under the constant threat that I think
Please
we all
stop.
recognize there, that there is no good faith basis to believe that they have any information. Again,
They traveled with her.
and I didn't hear a representation that anyone could impeach those witnesses.
I heard
with
it.
testimony that they otherwise.
I heard it.
It was a properly questioned even without further inquiry.
I heard that. Nope, the judge.
In that last that you're referring to the investigators?
Yeah,
Well,
no.
I mean, again, I think that's what Ms. Merchant is putting out here, that her star witness, Mr. Bradley, is able to impeach
Everybody.
every one of them. Is that what?
I didn't hear the representation that Ms. Merchant said that Mr.
She
Bradley
said
could
it.
infer that he has personal knowledge that investigators Hill, Green, and Ricks had knowledge of a cohabitation or a personal relationship prior to 2022.
Yep, she said it.
Ms. Merchant?
Maybe I missed it.
Depends on your definition, Judge, of cohabitation. That they stayed at the same house together, lived at the same house, yes.
Some of the audio is low.
And again, knowledge based on statements that they made to someone else who you do have under subpoena and you would intend to testify at the hearing.
Yes, and Judge, just for background, when Willis took office, Mr. Bradley had a contract. So did Mr. Campbell. They all had contracts. There were three partners: Bradley, Wade, Campbell. Three-person firm. They all had contracts to work at the DA's office. So they're all working at the DA's office in some capacity. Two of them had these taint contracts. So Bradley he had two contracts actually. He had a first appearance contract. So did Mr. Campbell. And Mr. Bradley and Mr. Campbell also had these taint attorney contracts where they're working directly for the anti-corruption. So it's not just this lawyer that he's partners with out in Cobb County. They're all together. They're all intimately together.
I mean, that's good by way of background, but really, I just think just to get over that threshold today. And Ms. Cross, I'll let you have the last word here, but I don't know how many times you may have argued at a closing the pattern instruction that a single witness, if believed, can establish a fact. What I'm hearing is, again, I think that looking at an abundance of evidence to show these things are not true at the hearing, but I don't see how I can make that determination on the front end without live testimony subject to cross-examination and assessment of demeanor and everything else that goes into those kind of determinations.
So she's asking him, right? So as a matter of law, meaning you don't need to hear any fact witnesses. You don't need to hear from witnesses. As a matter of law, you can quash the subpoenas because the testimony that is being sought is not relevant or doesn't exist. If that makes sense. And the judge is like, yeah, nah, we about to see. We gonna see. I love this. All right, let's get down to a couple more witnesses. There was another one.
Any final for me?
He's a disaster.
Only your Honor, that I'd ask the court to hold or reserve ruling on the state's motion to quash until Mr. Bradley, who appears to be the sole and primary source for the allegations that have been made, until he testifies at a hearing. And then if you're not otherwise inclined to quash the subpoenas, that they be revisited at that time.
All right, I think that is appropriate. So to that end, one thing I would...
He's not inclined to quash.
Obviously, as we talked about, the rules of evidence would apply, but this is much more so than I would do in front of a jury. I plan to be proactive about the application of 403 and 611. And if there's anything...
All right, he's going to be proactive about the application of 403 and 611. Georgia's statute of evidence is pretty much similar, parallel, mirrors the federal rule of evidence. Federal rule of evidence 403, which is, I'm sure, the same in Georgia, is the balancing statute, right? So the balancing statute, which says that evidence has to be probative, and its probativeness, right, needs to outweigh any unfair prejudice. any unfair prejudice. Okay, so that's what he's saying. He's like, I'm gonna evaluate it and see whether the probative value, how relevant it is, how probative means that it has a tendency to prove a thing, right? That's what probative has, a tendency to prove a fact. What is prove a fact, right? That's probative. It has probative evidentiary value. And if it even if it has that value, if it is outweighed, if that probative value is outweighed by unfair prejudice, then he will exclude that type of evidence. Okay, so that's what he's saying. Now 403. He also says 611. 611 is the statute that requires that a witness who testifies has to have personal knowledge. If that's 611A, and then 611B is how you regulate the courtroom. You know how the case in chief of the prosecutor, the judge regulates the order of the court. No leading questions on direct. That's 611B. So he's saying, you know, under 403 and 611, you bring in a witness with personal knowledge. That's required. But I'm also going to balance whether or not that testimony is unfairly prejudicial. And if it is, I'm going to exclude it. All right. That's what 403, a 403 analysis is.
If there's anything that is referring to, as in the words of the rule, harassment or undue embarrassment, I'm not going to feel inhibited from stepping in.
611.
Protection from counsel.
Yeah, I'm not going to let you badger witnesses, abuse witnesses.
So to that end, I do think that, again, on the court's authority to control the order and manner of presentation of the evidence, it would be important that from the outset, we're not talking about calling Ms. Willis as the first witness, and we need to get over a few procedural hurdles before we can get there.
So he's saying that we're not ready to, we're not at the threshold where I'm going to allow you to call Fonnie Willis yet. But I'm going to allow you to call some other witnesses. And if they can raise enough ire, right? They can bring forth enough evidence that an inquiry into Fonnie is required, then that's what the court will order. I don't think the court would disqualify her on this testimony alone. I think the court is using this testimony on Thursday to determine whether or not she is going to be required to testify in this hearing. We already know that I believe Nathan Wade is going to take the fifth because he already busted in some lies.
However, when it comes to the issue at hand, I think Ms. Merchant has established a good faith basis for relevance, and I don't see how quashal can be imposed here.
Quash denied.
I think it's a closer call with Ms. Green. That may yet result in quashal, but at this point, with each one of these witnesses, I would defer the ruling until we get further into the hearing itself. Or anything else, Ms. Cross? I know you could.
All right, hang on. I don't want to get into that. I want to
as it relates to
get to
Mr. Bradley. I think those just need to be handled.
This guy.
Questions are put to him.
So,
Banks.
Mr. Banks is an attorney from.
Our democracy depends on you.
Hold on.
It really does, folks. That's no joke.
God. They got these two old dudes out here trying to get votes.
So with it.
Democracy is in trouble. I'm so distracted by that ad that I don't even. Okay, Banks. Banks is an attorney who is also friends of Bradley, who is the star witness, right? Bradley has been complaining, and Merchant says this at other parts of this hearing, that people keep calling him, trying to get him to not testify, right? Not testify. And so Banks is under subpoena. Banks is under subpoena because they say he has personal information. So this is him here. He filed a motion to quash, and here's what he says about why the court should grant his motion to quash. All right.
I am Judge. Good afternoon.
All right. Good afternoon, sir. Any particular order you want to go in?
I can address mine first, Judge. I I'm sure the court has read the pleading. Ms. Merchant actually filed a response. I mean, in my pleading as it concerns my motion to quash, you know, of course, I represent that I have no personal or direct knowledge
He's on the,
concerning
yeah,
the issues that are germane to
there he
this
is.
court or that are pending before this court. I mean, taking a glance at what the court has already discussed with Ms. Cross' state's motion, I would submit that, I mean, if she's saying that I have relevant information and that at some point she has a witness to reflect that I have direct or indirect knowledge concerning
I
the
love
issues
this.
that are germane to this court, then, you know, I guess we would just have to wait and see. I would submit to this court, however, that I don't.
Yeah,
I mean,
bet
this
you
is a
don't.
fishing expedition as it concerns me.
Really?
I guess arguably, if she wanted to question me about whether I was considered special prosecutor, that certainly would be relevant. But based upon my lack of knowledge concerning any romantic relationship prior to her motions and the issues brought out before this court, I have no direct
You
knowledge, so I
don't
believe
sound like you
that she's
telling the truth,
position.
brother.
And of course, if she wants to respond and suggest that she has a witness that will contradict that evidence, then so be it. We can just deal with it at that time.
Okay. And I'd note, Ms. Merchant, that if it's solely to say that he was considered to be special counsel as well, excuse me.
Come on, Merchant. Slap somebody around.
That's going to go more into the qualifications area that I don't see as germane.
It's not relevant. Okay, how about this?
Over to you.
I think what Ms. Franks was
Yeah.
and that's what I planned on for him as far as some police testimony.
Sure, but I'd also like, he has other allegations, and if there's really nothing of relevance, then I think we need to at least have some kind of, as we did with the other witnesses, an initial upfront showing of that. So as we walk through, just at a surface level with the district attorney employees, what is it that Mr. Banks you think is going to testify to that you're going to be either able to, he's going to go along with you, or that you're going to be able to impeach?
It depends on how they impeach Mr. Brown. So he would be, there's some areas that they may.
The audio is slow.
And Mr. Riley has received phone calls from some people over the last several months trying to promote. So I don't know what the state plans on.
Well, and I can appreciate the need not to want to have to present your entire case today, but at the same
She doesn't want to disclose what
we may need some more specifics and
information he
we
has.
can do that.
I mean, it's just Mr. Bradley has received calls that he.
Bradley has received calls. That's what she said.
All right, and those calls would be relevant and admissible how?
It depends on if he's cross-examined about it, but it's also his fear of testifying. I mean, that's something that the state regularly asks witnesses if they want to be there to testify. If they to the veracity for the court. You know, he doesn't want to be part of this. He doesn't want to come and take the case. And so I think when he goes into that, it'll be relevant.
Is your contention that Mr. Banks made some of these calls?
Yeah.
Okay, Mr. Banks, back to you.
And back to you, buddy. So you've been calling the witness?
I mean,
Say what now?
to the extent that I had conversation with Bradley about it, I mean, there's certainly conversations that I had. I called him, and I'm happy to talk about it, but I called him on a personal level
You ain't
because
happy
one,
to
he's
talk
my
about
friend, and two, he's my fraternity brother.
Oh, he my frat.
And I know that
He my frat.
ultimately these type of things are very stressful.
Oh.
I was concerned ultimately about him being emotional given his prior relationship with
This
with-
don't
with
even
Mr.
pass the
Wade,
snark test.
not being able to see the forest beyond the trees when you actually are making decisions decisions on an emotional basis, and based upon
What does that mean?
my understanding that he had represented Mr. Wade dating back
Making
as far as
decisions.
2015,
Oh.
notwithstanding the fact that the divorce proceeding.
Hold up. What does he mean Bradley is making emotional decisions? Like deciding to testify or tell the truth? Oh, I mean, I don't know. I'm not understanding his argument. You called him because he's stressed out or you're concerned about his mental health, and nah, you sound like you tampering with a witness, buddy. That's what it sounds like.
wasn't filed in 2021. It's my understanding that I was concerned personally as my fraternity brother and as another member of the bar that he might arguably be running afoul of the attorney-client privilege. And so I did have a conversation with him about that and just expressed my concern. And it was a way to intimidate him. If that's what he's suggesting, I mean, I would take issue with that. And in fact, we laughed, and he said we need to get together for a drink afterwards. And
Yeah.
But that's what she wants to call me about, is my conversation with Mr. Bradley. I'm not sure that that's relevant at this point.
I bet you said you had no
Well,
information.
and I think that sounds like something that's just we're gonna have to see as the hearing begins, and we'll
You're not off the hook,
get
buddy.
through as to whether it becomes relevant and
So his motion
it becomes an issue.
is
And I
denied.
think, like,
also.
your motion would be able to be granted today.
Right. So he doesn't grant his motion either. Now, the last thing I want to show y'all. Oh, this was hilarious too. Another person up here, just their credibility just seems a little sus.
Clear.
So he represents. God.
A discrepancy with what Ms. Merchant just said. My client does not.
So he represents a woman who Ms. Merchant says has been friends with Fonnie for the past 30 years. And at some point, Fonnie lived at her home. And at that location, Fonnie lived with Nathan Wade. And that this woman has personal knowledge that they lived in this apartment together. That's what Merchant says. And this is his response to that.
Not own the whatsoever. She was leasing the property at the time.
Right, that matters.
And subsequently moved out of the property, moved into another property that she was renting as well. And Ms. Willis continued to reside at the property. So my client did not know anything that was going on at the property when she moved out. So just to clear that first and foremost, Your Honor.
I said owns and I meant like had authority over the unit.
All right.
Thank you, Judge. Furthermore, Your Honor, with regard to the situation, we called it a fiction expedition as well.
Everybody does.
Merely because Ms. Yerdy does not have any information as it relates to that of a romantic relationship or any relationship or what took place at the property after she moved out.
What about when she was there?
I indicated that information to that of Ms. Merchant from that of Ms. Yerdy. So she just has absolutely zero else to add to.
Okay. Ms. Merchant, do you have anything that would impeach that testimony if that's what she testified?
Of course she
At
does.
the hearing?
Yes, I think she has personal knowledge of their relationship.
And how would you impeach that?
I could impeach that with Mr. Bradley, but I believe that Mr. will.
She thinks Miss Yuri would tell the truth if she's on the stand under oath. Judge Scott McAfee.
Okay, Mr. Partridge, back to you.
Back to you, buddy.
But I would disagree as it relates to
Of course you
the
would.
Ms. Merchant made. If there's any information or testimony that Mr. Bradley has, we'd also ask the court to reserve ruling as to Ms. Yerdy's involvement with regard to this particular situation to see what information comes from Mr. Bradley. Otherwise, Your Honor, this would be a fiction expedition because there's no information that Ms. Merchant stated to the court that would suggest my client has actual knowledge of a personal or a romantic relationship or Mr. Wade staying at the particular residence with Ms. Willis.
All right. Well, it's just a matter of logistics here. Are you suggesting that Mr. Bradley should be allowed to go into statements he's heard from your client before she's called? Because generally you impeach someone after they've said something that they can be impeached with, right?
Yes, Judge, and I understand that, Your Honor. My concern, however, is that there's nothing that we've been presented with, nothing in the subpoena to Ms. Yerdy that says or indicates that she has, any information beyond that of what Mr. Bradley has said to that of Ms. Merchant, which is essentially all that we have, all that I've been put on notice about, is that Mr. Bradley, is the person, or rather, before today, there's another witness, a lawyer, that has something to say as it relates to that of.
So if Mr. Bradley were to testify and say the first called witness, he had a conversation with your client without going into what it was or what the substance was, and that generally that conversation, is that thing going to open your client up to being called?
Hell yeah.
It
Potential my ass.
situation, but I guess we'd have to get to that point. I'm not sure what.
Yeah, you don't want to get to that point. I'm hoping you don't get to that point.
Opportunity to reach out to Mr. Bradley, who I know also.
Don't reach out to him.
And, so I'm not sure, but according to
Mr. Bradley got a lawyer, y'all.
Repeated conversation with Ms. Yerdy, there's no information as it relates to her knowledge because again, she moved out of the condo or the residence.
Okay.
I don't understand how he thinks somebody moving out makes them dumb all of a sudden.
I know we weren't focusing on that, so I didn't highlight it, but there's also this issue of the media statements, all of those types of statements.
Moving around doesn't divest you of knowledge.
Security was the person at the DA's office who actually had an account to monitor the critical mention media. So Ms. Willis spent had a contract with a company called Critical Mention. They're a media monitoring company.
Sure, and remind me, is your argument just to say that
yeah, the judge is
is
like,
a motivating
I know
factor
where you're
in this
going
case
with this.
and is underlying her forensic comments?
Oh yes, definitely, Judge.
Okay.
Yes, and Ms.
Yeah, he's like, I got it.
One that actually,
I got it.
That had those
I like
reports. There
his
were two
judge.
people that
He's
had
like, I
access
got it.
to it at first, and Jerry's one of those. So she's one of the people that responded to Ms. Willis.
All right, last part.
These reports.
This here. Oh my God. So Miss Merchant is looking for a particular invoice. The invoice is invoice 22 and 25. She was requesting, not sure. I think it has to do with Nathan Wade or invoices that were submitted to the DA's office that were paid. And so this is some of that. Hang on, this stupid commercial.
With your deposition prep with counsel, quickly get creative ideas on topics and questions to ask witness. Getting
Let's go into specifics. I'm looking at a copy of Exhibit
specifics.
A,
the devil's in the
7
details.
bullets. Which of those are you contending have already been provided?
So it is our understanding. I don't know.
You don't know,
but it's our understanding that about
hold up.
Majority of the responses have.
Hold up. You knew this hearing was scheduled for today. You knew the substance of the hearing for today. You knew exactly what the substance was in the document production that was requested in the subpoena. You knew there was an application that the subpoena had not been satisfied, meaning you guys did not provide the documents that were subpoenaed. And when the court asks you what documents have been provided, you have the audacity, the temerity to say you don't know. These people are throwing themselves on hot fire for this woman. This feels so deliberate, right? Because you want to try to feign ignorance. Like, really? Wow. All right. Between these two women,
been provided and viewed by defendant's counsel, and it's not provided directly through the portal. It has been attached to the various motions as supportation in this case, and also readily available by public information.
Which ones haven't been though? Because that
Right. But I asked you, which one haven't?
It's our understanding that I don't have that direct information,
It's so
but
uncomfortable and fuck
in light
Fannie
of
for
the
putting people in this goddamn position.
that have not been
Not right, man.
there is no relevance to the information. We have a criminal case. These things that they're asking for there's no connection, there's no relevance, and the defendant admits that there's no reason in which documents there was no reason provided as to why these documents were requested.
A reason
in order for a subpoena to be issued in this fashion, there needs to be a material reason for the subpoena, and in this case we do not have one.
Okay, Ms. Merchant, what haven't you gotten?
So you have complied? That's your argument?
All of the invoices for Mr. Wade, I started asking for those back in September through the open records, and I got some of them piecemeal. I got a couple others that's to their motion. So the open records officer said I had gotten everything, and then he attached a couple more. So now I have even more, but there's still a couple that are outstanding. So there's several that are outstanding, and we put that in a very detailed pleading letter to the Fulton
She's laughing at them.
County Attorney. We have not received a single invoice from Mr. Bradley. We have a current contract for Anna Cross or Don Floyd, and the issue with that is that Ms. Willis made statements that she paid them the same amount of money. The contract we have for Mr. Floyd, that is an incorrect statement. He was not paid the same amount of money. We do not have either current contracts for either of those folks. We don't have anything about the time off requests. We don't have anything about the reimbursements for Ms. Willis, and we don't have anything in regards to the last bullet point.
What makes you think that travel reimbursements? Because everything's
it's all personal travel, and I don't believe that it is. It's related to us showing that Ms. Willis had personal and a financial interest in this prosecution. Reimbursements for travel. We have some reimbursements.
Follow the money.
For Mr. Wade's travel. So are those trips connected? Those we're seeking. We sought all of these through open records. These are open records, but the county has been refusing to give them to us despite way longer than 3 days.
Open records.
So before this hearing was set, we already were in litigation over the open records violation. These are things we're entitled to. We don't have to show that they're relevant in the open records context.
Facts.
But so then we get a
Just
hearing,
like,
and
right.
instead of waiting for the litigation and them to actually give us the documents to the open records, I have to get them in through a business certificate. So I can't submit an open records.
Right.
I cannot submit all of these invoices. These invoices are hearsay.
They're inadmissible.
I need a
That's hearsay.
business record
All right.
certificate.
So you guys understand?
Send a subpoena to the county.
Then real
for a
quick.
business record certificate.
A bunch of documents from the county that she wants to put into evidence. She hasn't gotten everything, but she's got some of them. So the next argument is she can't get them into evidence because those documents are hearsay unless they fit within a hearsay exception, right? So the hearsay exception that she wants to fit them in is the business record. It's a business record, so it's self-authenticating. It would be self-authenticating under 901 if it contains the proper certification from a custodian of records, right? And so she's saying, I got some documents, but I don't have any certification. And if you guys are not willing to certify your own documents, then I'm going to drag your ass down in the court and put you on a stand so that I can authenticate these documents one way or another. So usually what happens when you threaten to do that, they send you a certification because don't nobody want to come down to court just to say I'm the custodian of records and those are in fact true copies of the records that are in my office. Right? So that's what she's saying. Like, listen, I need a certification. Y'all playing games.
They have to certify the documents they've already given me. Plus, they've got to give me the documents that they haven't given me.
Okay. Let's keep making our way down the list. I can see your argument on travel and vacation since that's at the core of your allegations. The last one, though, all hiring outside counsel. that seems to go more towards what I indicated, has a lot less.
I didn't want to deal with.
Hiring an outside counsel for.
Generally, it says any outside counsel, process for hiring bids, payment of outside counsel.
Are you talking about? And I just want to make sure.
The final bullet. Any and all four.
Oh, okay, I understand. I want to make sure because I printed theirs out right before I left the office. This is in regards to a Board of County Commissioners meeting that was held in November 2023. There was a very detailed conversation between Dexter Bonds and I can't remember her name, but she's the purchasing director for Bolton County. They had a very detailed discussion and said that there had been a problem with the processing invoices with the district attorney, and that they had to talk with her and go through a new rebidding with them because essentially they were having services that weren't going through the proper channels. We believe that these documents are relevant to show the personal financial interest of the district attorney.
How so?
Getting things paid for without approval.
Okay, so that's going more towards the approval aspect of it, and the maybe county, what you would refer to as impropriety and sticking to county regs. Is that fair?
Not necessarily county regs, but sticking to the statute, which is the basis for all of this. The statute that was not followed to the basis, but also what are these? Is she having a personal?
Okay, so here's because she's laying it out like, why don't I have these documents? And the judge is like, why doesn't she?
It's a separate open request that
Why doesn't she have them?
office. All of that information has been provided.
They're not
But in terms of the open requests that were submitted, the separate open requests that were submitted to the district attorney's office on a separate open records request, we wouldn't have personal knowledge as to what requests have been fulfilled or not. In terms of what we have in possession in our office, we have that information has been provided already by the district attorney's office.
But you don't know what it is.
There's nothing outstanding pursuant to this subpoena that we would have that they don't have access to already.
Not true.
Okay, so just to be.
I don't have any authentication. I haven't received one single authentication from them.
And I think that's what it comes down to. She's seeking authentication. We just want to make sure that we are fulfilling our end, and if this is information that she has already received, by abusing the legal process.
Now she's abusing.
With subpoenas, just saying authentication is not a proper use of.
No, it is.
The system, nor is it coupled with the allegation as Ms. Merchant. So emphasize pending against the district attorney's office regarding an alleged open records act violation.
How else would she authenticate?
Right.
Were you planning to come down?
I love this judge.
Have someone personally.
You coming down, babe?
Testify to it?
Without a subpoena?
I'm sorry, I didn't hear the question.
Well, I mean, more to the point. It seems this conversation keeps shifting. It's either the county attorney does not have the items requested, or is the sole issue now just authentication of the items he already has, the defense already has.
Your Honor, may I be permitted to speak? This is Shalonda Miller. I am the designated records custodian for Fulton County. And,
Okay.
I might be able to provide some clarification.
Let's go.
Individuals request open records. We're not required to authenticate responses to open records requests. Part of the
Judge.
We're also not required to produce anything, even when individuals. We do.
Oh.
I'll give an example. There, Ms. Murphy.
No. You're not doing that. Thank you, Judge.
But I guess all that would remain then is what Ms. Merchant is saying, that if all she's after is authentication and it hasn't been provided, but she thinks that the witness she has
Never
subpoenaed.
requested authentication, Your Honor, absent this subpoena. That wasn't a request. The first time we saw anything about authentication was at the service of the subpoena.
Okay. All right. So, Ms. Merchant, where does this stand then?
Judge, first, that's how how we have to get business record certificates is we have to subpoena the witness, and if they want to avoid coming and testifying, they could submit a business records affidavit. We drew one up and submitted it with a subpoena. So I believe we followed the proper procedure to get these records certified. As they've given us everything they have not. As far as the first bullet point, we do not have invoice number 22 or 25.
22 and
It's not been attached to
25.
anybody's pleadings. It's not anywhere, any place.
Start there.
So,
This is the last part.
invoice 22 or 25, something that's
Where?
in possession of Fulton County.
Not that we're aware of, Your Honor.
Who would typically have retained custody?
Hold on. She's the custodian of records. They're asking her where the records are. And she's like, I don't have them in my possession. But where are they? How come nobody knows where these invoices are? These are Nathan Wade's invoices. Again, the appearance of impropriety speaks volumes. Volumes. Where are the invoices? Let's hear what she has to say about where the invoices are.
Those kind of things. Does it reimbursement request? Does that just stay with the district attorney, or would Fulton County have all those?
The district attorney will follow up with our client, but it's our understanding that they provide the records that you have. I'm not sure what R25 will not be a part of those records, but we can confirm that all that we have in our possession has been provided.
She's speaking very carefully. If you notice that, we're confirming that all in our possession, which is kind of like saying, because we got rid of and destroyed 22 and 25, so we don't even have that in our possession. We sent you everything we have. And I can say that and with a clear conscience because I know it doesn't exist anymore. That's what it feels like. I'm not saying that's what it is, but God damn it, that's what it feels like. That's what it sounds like. That's it. That's what it feels like. That's what it sounds like. And she doesn't look comfortable doing it. Neither of them do. Neither of them do.
Okay. All right. And Mr. Merchant, you were talking about, you said that the next three bullets were invoices for Mr. Bradley, contracts for Ms. Ross and Mr. Floyd. I guess turning to Ms. Monroe or Ms. Miller, are those also things that you're saying are not in possession of Fulton County and only in the possession of the district attorney?
We're trying to delineate between the district attorney and Fulton County. What we're saying is our clients provide us those records, the records that they have in their possession. There are presumptions about what should exist and what we should have in our possession, but just because individuals think they exist doesn't mean we necessarily have them in our possession.
What?
For whatever reason.
What?
Understood.
No.
Do you have them?
Yeah. Do you have
No,
them?
not that we're aware of.
Ooh.
And we have conferred with our client, and it is our understanding that everything that is in the client's possession has been provided.
So where are they?
Okay. So then that sounds like a follow-up question to their client, the district attorney's office, if they've been under subpoena for these same documents.
See, they're going to get Fonnie on the stand doing this bullshit.
Subpoena is saying, the entity subpoena is saying, and unless counsel has a reason to show that they should do, I think that's usually the end of it.
Ms. Cross here today, I believe under contract, she's been submitting invoices, so I mean, maybe they just come and testify as to how they have people under contract.
It's not that it doesn't exist, it's where is it? And have you subpoenaed the right entity or person?
They ain't got the right people.
Have represented that they represent the district attorney.
Right.
They even filed this motion to quash saying they represented the attorney.
Right. So they have it.
Very good point. So,
thank you, Judge.
Ms. Miller, Ms. Monroe, regardless of whether they're down the hall or across the street, if you are the entity where legal process has to go in order to serve
Ooh,
the
they not happy with that.
production, how does that get you out of complying with the subpoena?
It doesn't.
Your Honor, I'm so sorry. I don't
Yes, you do.
need to interrupt. You tell me to wait, and I will gladly do it. But as far as we're talking about a subsequent contract for me, there is none in existence.
Now that gets them off the hook. What about the question he asked them?
And that's So that's, again, I keep hearing two different things. Either it exists or it doesn't exist, or someone has or doesn't have it, and then kind of keep flipping back and forth between the two. I'm trying to nail it down.
Your Honor.
We call that playing fast and loose with the court. That's what we call that. Playing fast and loose with the court. That's not cool. That's not cool. Yeah, you see my office is in transformation, right? It's going to be a nursery. Yeah, that's why you see the broom over there. Yeah. I'm cleaning it all out. All of this stuff is coming down. And I think they're going to paint it pink for my granddaughter. Yeah, I got a granddaughter on the way. It's bugged out. Yeah. All right. We're almost done with this. This is the last thing that I want y'all to see. Her. I think this is her response to the court.
For being unclear. Anything that we have in our possession, that our client has in its possession, we have provided.
Okay.
There are assumptions about things that we have that are inaccurate because we've provided everything that either our office or the district attorney's office has.
Okay.
We're not trying to hide it.
No, that makes it clear. So
No, it doesn't.
You're saying that you would be, either you or collectively the DA's office would be responsible for providing these if you have them. And your understanding, just again, going back to the first bullet point, is that a invoice 2225 has already been.
It may not have been provided, Your Honor, but if it hasn't been provided, it's because we don't have it in our possession. And when I say we, I'm saying collectively, the district attorney's office.
Thank you. I think that's better than
So it's somewhere. Y'all just don't have it.
Follow up and confirm.
We will definitely follow up we have followed up numerous times with our client. We're looking for the person.
So I'm gonna stop right here because what I think is gonna happen is that they are gonna have Fani come testify. All of the subterfuge that you see going on, that's gonna backfire. That's gonna backfire. And while this court has been very patient and saying that we're not gonna call Fani right away, we're gonna call. The fact that y'all are playing fast and loose with the court, you can't find documents, you don't have them, they're not in my possession, we turned over everything and we don't know where it is, we might have it. That's nonsense. What's going to happen is then the person who has the information is going to be on the stand, and that's Fani Willis. You're not helping her. You're not protecting her, right? This is going to backfire, and then she's going to get on the stand, and what? Then what? Then what? Because he's already perjured himself. He's already perjured himself. Submitting affidavits. When you're an attorney, you submit an affidavit or an affirmation. You do that under the penalty of perjury. So you submitted several affidavits in your divorce proceeding where you said you wasn't dealing with anyone. And then you submitted an affidavit in this proceeding saying that you've been dealing with Fani since 2022. But that affidavit you provided to your divorce in your divorce case was from May of 2023. So that math is not mathing, Brother Wade, which is why you standing on the fifth, huh? Standing on the. Here's what needs to happen. Let me say this before I get off. Before Thursday, and I hope you're listening to me, Fani. Before Thursday, you need to recuse yourself from this case. That way, nobody testifies. It's over. It's over. They'll appoint another prosecutor or have the case prosecuted by an independent prosecutor, independent counsel that's appointed by some members of some goddamn committee somewhere, right? And you are not involved at all, right? That's what you need to do. Step down and let somebody else prosecute this. That's the only way that saves you from getting in that chair. It's the only way that saves your boyfriend from having to take the Fifth Amendment. All right? That's the best thing for you to do. So by Thursday, I need you to step down because you cannot make this better by continuing down this path. You cannot. You are only going to exacerbate it. It's only going to be made exponentially worse. So that's all I got to say about that. Hopefully, she will take some advice, some sound advice. It's not about self-preservation, right? You've got people who are trying to help you with this subterfuge, and it's not fair. It's not fair to them. They deserve better. They deserve better. And you would save Bradley from having to come testify about all of this nonsense that's been going on, how long you two have been together, and all of the people in your office that know. Because they either witnessed it or you saw them, or he saw them with you all, or he overheard them having a conversation about it, whatever may have you. He is like the key witness that's going to topple the whole thing down. So step down. Step down. Save face and step down. They got your father on the list, sis. They got your father on a list to come and testify. I don't care what he would have to say. That is so unfair. That is so not what he wants to do. That is so not a position you want to put him in. Even if he's telling the truth, right? It's not. So spare us all and step down. That's all I'm going to say about that. Spare us all and step down. All right, family. I had to come on here because I wanted to make sure y'all understood what was going on. I saw some people talking about stuff. People don't really understand the import of things that happen in court because they're not lawyers. They're not lawyers. So I am. So hopefully, I tried to explain a little bit. I'm going to be checking in on Thursday. I'm going to be here. I might be live tweeting. I mean, not live tweeting. I might live stream my reactions to the actual hearing because I should be around Thursday. I should be good. I got Pilates class, but I might be able to get out of that. All right. I love you. I really do. It's your girl Ikie here. I'm sorry. I can't see the comments. I don't like Restream. I'm telling you right now. I'm going to find another. I think there's another one. I'm going to try that one out. This was trash. StreamYard. I don't know what happened to y'all. I don't know why y'all sold to these people, but I won't be using them again. Okay. Yeah, I said it. Restream trash. All right. All right, family. Y'all be good. I'll see y'all on Thursday. Maybe sooner, but definitely on Thursday.